Former President Jacob Zuma and the the Department of Correctional Services, forgive me, their challenge on a High Court decision that ruled his release on medical parole last September was unlawful. He served 2 months of his 15-month sentence. That, of course, was imposed by the Constitutional Court after he refused to continue his testimony at the State Capture Commission. Now, the Medical Parole Board, the advisory board, found there was not sufficient grounds to give him medical parole, but a Defence Force medical report advised he be released because they said there weren't enough facilities to look after him 24 hours around the clock. Prison's boss at the time, Arthur Fraser, decided to release him. So that decision was challenged by the DA, the Helen Suzman Foundation. Parole, though, was then overturned. Now Zuma's legal team is in Bloemfontein challenging that decision. I'm joined now by Cathy Powell, Associate Professor in Public Law at UCT. Good evening, Prof. Thank you so much for joining us. I've given that long explanation because it really is quite complicated. So let's see if I'm right. At the heart of it, does it actually hinge on the powers of the Correctional Services Commissioner, Arthur Fraser at the time, whether he actually had the right to make the call he did?
Yes, I think that is the central issue. A second related issue is if he didn't, if the court finds that he did not have the power to overrule the medical board, was the court entitled to replace the National Commissioner's decision with its own, or should they have referred the matter back to the National Commissioner to decide all over again? But I think you're right. The main issue is, could he make that decision against the advice of the Medical Parole Board?
And of course, quite a lot has come out about the Medical Parole Advisory Board, which was actually set up, my understanding, in the wake of Shabir Sheikh getting medical parole and then, of course, being seen playing golf everywhere. And that board, my understanding, is to actually make sure that people are fairly granted medical parole. And I think it's to get the balance. You don't necessarily want to release someone for their last day of life if they really are terminally ill, but equally, you don't want someone to get out of jail pretty much free. So what is your understanding of what needs to be decided in terms of the powers? How much power does this advisory board have? Because that's been one of the central issues today. You know, the DA saying, well, actually, they do have the power to make this decision. It needs to be stuck to. And Fraser can't really overrule that.
Yes, the medical board advises on whether one of the 3 criteria for medical parole are met. The reason it's called advice is because they can't decide all 3 criteria. They can only decide one. There are 3 criteria that Zuma needed to meet to get medical parole. One was being terminally ill. So that is a very high threshold to meet. The other one was that there'd be a low risk of reoffending. And the third was that there'd be there'd be a way of looking after him. There'd be a suitable place for him to be kept. Now, the Medical Parole Board decides that first issue, but it decides it. There's nothing in the Act to say that the National Commissioner can make up his own mind on whether the person is in fact terminally ill. And what we forget when we hear that, well, you know, the Defence Force said this and Zuma's own doctor said that, is that all those documents were before the Medical Parole Board when it made its decision. So it looked at the full list of the full content of submissions made to it on Zuma's state of health, on the facilities available to look after him, what he needed, and it expressly then recommended against medical parole. So it's only if the Medical Parole Board had said, yes, he is terminally ill, that the National Commissioner would then have had the discretion to say, well, let me see whether conditions 2 and 3 are filled. But as 1 wasn't even filled, the National Commissioner didn't have any discretion at all.
Interesting, because this issue of 24-hour care is being used as quite a strong argument, saying that the Defence Force is saying that they assessed it and there wasn't enough care. And my understanding, and please, you probably know better than me, but the reason the Defence Force doctors were looking after Zuma is because, as a former head of state, he would fall under the Defence Force in terms of his medical care. Am I right there?
Correct, but they can do that anyway, whether he's in prison or not. Remember, he wasn't in a prison cell, he was in the hospital there. So he's getting far less immediate access to medical care under his wife's control in Kandla than he would be in a prison hospital where the South African Military Health Service can also look after him. So that argument does not work.
So, Cathy, let's talk about the issue around the terminal illness. Now, you said that they never said he was terminally ill. Am I correct?
Yes, the evidence that was provided to the court didn't in fact include a statement that he was terminally ill. In fact, Zuma's own doctors were particularly cagey when they were asked that question. So they were asked, I can't remember the exact wording, but the question was, is his condition irreversible? That was the question.
Right.
And his own doctor said simply that his condition is deteriorating. That's not an answer to the question.
Yeah.
So no, there was nothing put before the board to say that he's terminally ill.
So with that in mind, that's quite interesting. I want us to listen to a clip, and this is the part of today's proceedings where the Supreme Court of Appeal judges were saying, look, we have been handed a redacted report. We don't even know what illness he's actually suffering from, and then we can chat again afterwards. Let's take a quick listen.
Sure.
National Commissioner, unlike Justice Matojane, unlike my learned friends, unlike the DA, unlike the Helen Suzman Foundation, unlike anybody else, had access to the full Monty, had access to the unredacted information. So in which world can we say that without knowing that information that's redacted there could be saying, and I'm exaggerating for effect, could be saying the patient is going to die tomorrow. As I say, I'm just exaggerating for effect.
Or it could say, well, there's nothing wrong with him effectively.
It could. But then whose baby is that? That's the point. Well, it's the owner's bearing party. The owner's bearing party, that's where the maxim comes, Justice Mahogi. You're quite right. Let's assume, let's be fair and say that the information there could say he's going to die tomorrow, or the information there could say, it's fine.
So the real issue.
But the court is then hamstrung in its review powers.
Yeah. Yes, it is, because the party that is asking it to review has not brought the information for that court to review. That's what I've just read out about.
But the commissioner is very categorical about what he took into account.
Yes.
Of all the things that were placed before him, he says, this is what I took into account.
Yes.
And that's telling. That's the respondents say, this is what he says he took into account, and it's borne out by what he himself he says he took into account.
Thank you, Justice. But what is this?
Well, he sets it out in his reasons.
No, but
that he supplies.
No, I'm sorry, Justice. One cannot do that. If it says at 8.1, I took into account the report of Dr. Mafe, the report of Dr. Dabula, the report of Dr. Mduchwa. Those are the reports he's referring to.
Well, as a public authority making a decision, he has the responsibility of making a decision that's informative to all the interested parties.
Yes, but Justice Dabula, how do you know?
So those parties that are interested in the decision will go to his reasons and work out what he took into account.
Yes.
That's what is being put in the spotlight in these proceedings and before the High Court.
100%.
So, Cathy, you're going to explain this to us, but is it important that the Supreme Court of Appeal judges know exactly what's in the report to assess whether Fraser made the right decision in terms of comparing it to what the regulations and what the Act says his powers are? Just talk me through the importance of this issue.
No, it's not important. What the advocate is trying to do there is, I'd call it sleight of hand, because he's playing with the whole concept of onus. Now, usually in a law case, the party that brings a case against another party, so A brings a case against B, A's got to prove the allegations that will make the case successful against B. That's called onus, and that's the word that Advocate Mpofo was throwing around a lot. But what he's forgetting, and he's ignoring it when the judges try to point it out to him, is that what we're dealing with here is a decision made by a public authority, and that authority bears the, let's call it onus, the duty, the responsibility to justify its own decision. So what the judges are saying is, look, when the National Commissioner granted this medical parole, he gave reasons for it, and they did not include that Zuma was terminally ill. They included a whole lot of thoroughly irrelevant things like, well, you know, we might have more riots, and this poor man is frail, and he was the president of the country, so this would be unprecedented. So what the judges were trying to get the advocate to notice is actually it's not the applicant's duty, or now the respondents, it's not the DA's and the Helen Suzman Foundation's duty to prove that Zuma was not terminally ill. It's the National Commissioner, as the public authority that made that decision, that exercised that public power, it's for him to justify his own decision. And if he cannot do it in a way that shows that he was rationally applying the relevant criteria, then he has not made a lawful decision. So I think what we've got there is a tangent.
Yeah, okay, that's interesting. The third issue, you spoke about the fact that there were concerns that there wasn't 24-hour medical care. I mean, the Correctional Services Department is involved in this as well, and they're basically saying that as well, if my memory serves me correctly. That seems to be the only issue that could actually be, that he could use. But you're saying that the Medical Advisory Parole Board saw all those reports and still decided that actually he was definitely in better hands where he was, and it was actually
Yes.
they were definitely going to be able to look after him. Cathy, I have to wrap because we've just heard the judgment has been reserved and we're going to dash back to Bloemfontein, but I want to ask you about the importance of this case for parole law. Because at the end of the day, the DA is saying, oh, Zuma got special treatment, but this is a law that is going to affect many more people beyond Zuma once it's established the powers of the Correctional Services Commissioner. Am I right?
Well, yes, except if I read the case correctly, the Commissioner acknowledged that a National Commissioner has not overruled the Medical Parole Board before. So it's not going to make that much of a difference if the court simply points out that the National Commissioner is bound to respect the decision of the Medical Parole Board that the patient is or is not terminally ill, which is the only medical condition that is acceptable for early release.
And Cathy, is it clear from your viewpoint how this case is going to go, or is it really hard to say at this stage?
Look, for me, it's a no-brainer. I would be surprised even to get a dissenting opinion. I think that Section 79 of the Correctional Services Act makes it very clear what the process is, and you need a medical parole board to decide whether one of the criteria necessary for medical parole has been met. So I think that all this talk about onus and who's proven what and all of that is a lot of distraction from the main issue, and I think the decision is likely to be that the National Commissioner was bound. What the court will say the remedy should be is a second question, but I think in that respect as well, it is likely to say Zuma must go back to prison. He can't just simply say, well, you know, my prison sentence was running while I was out on medical parole, because he shouldn't have been out on medical parole.
Yeah, that is a very interesting point. Cathy Powell, thank you so much. She's Associate Professor in Public Law at UCT. If she's right, and the Supreme Court of Appeal does reject that appeal, Zuma's incarceration would have ended this October. But if the court says, look, we'll accept the medical parole, it's not really his fault he was released, it was an incorrect decision, should he be prejudiced by that? Should he go back to prison? We will be crossing to Bloemfontein this hour, speaking to Aviwe Mtila, where, of course, proceedings have